Welcome to Washington Legal Foundation's web seminar. My name is Glenn Lammy. I am Executive Director and Vice President of the Foundation. For those of you not familiar with the Foundation, we are in our 45th year of free enterprise-oriented advocacy through education, publishing, programs such as this one, op-eds. We are involved in just about any issue that might affect the creation of capital and the conduct of free enterprise in America. If you're interested in learning more about us, please spend some time on our website, which is wlf.org. In order to visually depict the overarching nature of environmental, social, and governance concerns that the public companies face today, one of the slides our speaker will present has the E, the S, and the G as overlapping circles. I think one could use a similar image to depict the internal and external pressures the ESG movement have inspired, which our panelists will be delving into today. One circle, you'd have the self-initiated external disclosures and internal policies public companies undertake to demonstrate how ESG they are, for lack of a better term. And a second, there would be formal proposals, enforcement actions, sub-regulatory activity that federal agencies and officials are pursuing to advance an ESG ethic. Third would be shareholder and other stakeholder actions, most prominently in the form of annual meeting proposals, but also in the form of civil lawsuits. At the intersection of these three circles is an enormous amount of legal and regulatory risk. We're pleased to have with us today two attorneys that discussed ESG-related legal risks during a September 2021 WLF webinar, and a third attorney who was participating in the WLF event for the first time. We thank everyone for joining us today and everyone who's on with us live. Just to let you know, the event's being recorded. We're going to be utilizing a slide deck, which I put into the chat function as a PDF. You're welcome to download that. And we're going to be accepting questions. Use the Q&A function at the bottom of the screen to do that. We introduce our speakers. Yogita Ashley is a partner with Thompson Hine LLP, and co-chair of the firm's Public Companies Group and co-chair of the firm's ESG Collective. She currently serves as vice president of the Ohio chapter of the Society of Corporate Governance and is a member of the Society's Corporate Governance and Sustainable Practices Committee. Brian Valerio is the senior vice president at Alliance Advisors. He advises public companies from Fortune 500 to small cap biopharmaceutical companies on a variety of corporate governance matters, including environmental and social issues and proxy voting. Last but not least, David Wilson is investigations and government enforcement partner at Thompson Hine and serves as a partner in charge of the firm of the Washington, D.C.'s office. David has 31 years of experience representing a wide array of businesses, individuals, and complex civil litigation. Yogita and Brian and David, let you take it over from here.
Well, Glenn, thanks so much for having us, and thank you to everybody who has been able to join. We have been talking about ESG a lot, and really thrilled to be here today. The Securities and Exchange Commission has been incredibly active over the last 6 months or so, and a lot of proposals have fallen in the area of broadly defined ESG area. So one of the movements that we have seen is the ESG expanding to include your traditional compliance areas as well. So looking at the ESG rulemaking, we're seeing proposals on stock repurchases, insider trading, reporting on cybersecurity risks, and of course, the climate disclosure proposal that we'll spend some time talking about today. But before we go there, we thought that I'll ask David to sort of briefly tell us what's the landscape as far as the litigation and the regulatory activity, and then have Brian talk to us about environmental and social shareholder proposals. So David, perhaps you could go next.
Let's see the next slide. Welcome everybody, and thanks for listening in. This is just a quick overview. There, you know, this ESG stuff is so wide-ranging, but when you think about litigation and enforcement risks, here are at least some of the things to think about. We'll go into these in a little bit more detail as we go on. I think, as is normally the case, when you talk about enforcement concepts, the question is, how accurate are the disclosures and the marketing claims that you're making? Whether you're talking private litigation or regulatory and enforcement, by the SEC, by the FTC. The CFTC is getting into the game, and state consumer protection agencies are as well. It's all really about what kind of claims are you making, what kind of disclosures are you making, and can you back them up? And we'll talk about some specific examples as we go down the road. I won't get into detail now, but just pass it off to Brian.
Thank you, everybody. Appreciate the opportunity to be on the panel and talk with you guys. Nice to meet everybody. So let's delve into some of the environmental and shareholder proposal trends that we're seeing for the 2022 proxy season. So 2021 was really an unprecedented proxy season from an environmental and social shareholder proposal perspective. There were many companies and advisors who expected a very challenging environmental and shareholder proposal season this year, with even more shareholder proposals being put on ballots this year, largely due to the success of some of these proposals last year. And what we're seeing early on is that 2022 could in fact even break the 39 majority votes that we saw on E&S shareholder proposals last year. That was a record. And we might be able to even break that record this year. So it looks like the trend is continuing, where we're seeing increased support from institutional investors and advisory firms on environmental and social shareholder proposals. So I thought what I would do would be lay the land, give you guys a little overview of kind of how we got to where we are, and then delve into some specifics. So what we're finding is that institutional investors, their views are evolving pretty quickly. They're expressing these views by actively voting for shareholder proposals, particularly on E&S issues, in ways that they didn't only a few proxy seasons ago. This is leading some companies to be caught off guard by the level of support that these environmental and social shareholder proposals are receiving, particularly if these companies haven't received one for a number of years and are now trying to look back at what happened only in 2019 or 2020. That data is really going to be far different today than it was back then. So it really emphasizes the importance of companies understanding their shareholder base, their shareholders' expectations, as well as their peers' ESG practices. Companies also should really be mindful of how their disclosures align with some of the most prominent reporting frameworks, SASB and TCFD, as well as what the ESG ratings agencies are saying about them, like Sustainalytics and MSCI. It's not necessarily that you're going to let the tail wag the dog, if you will, but you are going to want to have an understanding of what these key issues are and what these key reports are saying, so that you can understand if there's areas for improvement or areas where you can build out disclosure to try to align yourself with these expectations and maybe head off a shareholder proposal before you receive it. So
right. Just to jump in for a second, I think ESG rating agencies are so frustrating because there are hundreds of them, and a lot of times they'll come out with ratings that are inconsistent with each other. So when I talk with clients, and I guess my question is whether you agree, is you can't design your program to really focus on to chase the rating, so to speak, but you should take a look at which ones your main investors care about. And you mentioned the two, and I think those are the two that are emerging, because Sustainalytics and MSCI in a lot of cases are the important ones.
I completely agree with everything you just said. Yes, I think you're doing a disservice to yourself if you're not aware of what they are saying about your company. But I also think that you don't need to necessarily chase the highest score possible. What you need to do is be mindful of what's material to your company, what are the most important issues to the company and your stakeholders, and then disclose appropriately based around those issues. So you got to do an internal assessment as well, and not necessarily be reactive to what you're reading in these reports, but it is important to have a sense of what these reports are saying. So the other thing that this is really emphasizing, the increased support for shareholder proposals that we're seeing, is how important it is to talk to your shareholders during the off season and engage with them. It helps identify blind spots. It helps companies explain their ESG strategies and their narratives. So it's a really useful exercise for companies. So what we're seeing, as you see on the slide, filings are up. Over 500 environmental and social shareholder proposals have already been filed this year, which outpaces what we saw in all of 2022. Shareholder proponents, they're looking at last year's success. They're looking at the growing focus in the country and society around social issues and environmental issues. And they're also looking at the regulatory changes. And all of this is combining to make it a very ripe environment to submit shareholder proposals. And they're capitalizing on this by submitting more shareholder proposals. Proponents are also finding that companies are more willing to negotiate now, because these companies, they're looking at the same data that we're talking about today. Companies are aware of what's happening. They're aware of the growing trend of increased support from institutional investors. So they're willing to come to the table and negotiate and understand if there's a compromise that can be made as to what makes sense for the company and what would satisfy the shareholder proponent. There's also a bit of a hesitation around opposing an environmental and social shareholder proposal. There are times when companies are mindful of the fact that they don't want to necessarily potentially alienate some customers and or even their employees by taking a stance that might run counter to what some of the prevailing views are on some of these big issues.
And as you say, one is it's much more difficult to exclude environmental and social proposals now because of the changes of the way the SEC looks at them right now. And then the second thing is that I think companies understand that if it's put on the ballot, then it's really, really likely that it will receive pretty high support.
That's precisely right. I mean, what you'll see is we're going to discuss some of the proposals that have received majority support already this year. There's a number of instances where both ISS and Glass Lewis, the two most prominent proxy advisory firms, are supporting shareholder proposals. And when that happens, it's similar to when you have both ISS and Glass Lewis opposing Sam Pei. These proposals are likely going to receive majority support in that scenario. So this is the type of calculus that people are doing prior to filing the proxy. Upon receiving shareholder proposals, they're analyzing what the historical recommendations have been for this type of proposal and how institutional investors have voted on these types of proposals in the past. And that data can then inform them when they're making the decision about how to engage with the shareholder proponent. So it's a nice, important step to take in that process. So two of the most prominent topics that we're seeing this year are around diversity and climate change. Many of the shareholder proponents this year, they're seeking proposals or they're filing proposals that seek details on carbon emissions and company diversity policies, practices, as well as data on the workforce. So the change this year on the disclosures is companies are really calling for quantitative reporting on climate change and diversity. They're really focused on what companies are doing to reduce greenhouse gas emissions with a goal of getting towards that net zero emissions. They're also interested on how companies are combating systemic racism. So those are two of the key focus areas that we're seeing: carbon emissions reductions and risk associated with really contentious social issues. So just a few stats for you guys. As of April 1st, there were already 55 racial justice and civil rights audit and 54 GHG emissions reduction target proposals that have been filed. So if you just look back to last year and compare those numbers to the overall shareholder proposals that were submitted last year, those would have been the second and the third most common shareholder proposals submitted in all of 2021. Just shows the real emphasis that shareholder proponents are placing on these two key topics. So there's a real sense that there's an opportunity now. There's a moment of change, if you will, for corporate America as investors are increasing their engagement and are filing more shareholder proposals that are specifically tied to environmental and social issues. But let's also not forget about governance, right? Because governance is still a hot topic for shareholder proponents, particularly the Chevedden Group. They're a very common filer, probably the most prominent filer of shareholder proposals, and they typically focus on governance issues, and this year is no different. They're focusing this year on special meeting rights, whereas previously they were really focused on the right to act by written consent. So it's a pretty technical use of shareholder rights, and one that isn't really used all that frequently, but it is something that they think is a really important point of emphasis, and one that you have seen some support from institutional investors and the proxy advisory firms, as we've seen a couple of these proposals pass already this year. So let's flip to the next slide, and we can delve into what some of the early voting results look like for 2022. So the trends in 2021 are largely continuing in 2022. We're seeing some early votes that picked strong support for environmental and social shareholder proposals. We've seen 6 environmental and social shareholder proposals already receive majority support, and 9 as of April 1st, and there's additional 3 that have trickled in since then. So we got 12 shareholder proposals have received majority support, 6 of which are on the E&S side, 6 are on the governance side. So you're seeing some really strong support early on, including 2 that are around the racial equity or civil rights audits, which is, again, that real point of emphasis for shareholder proponents this year. We're also seeing an increased number of withdrawals, and omissions are declining. This is largely due to what we were just discussing about how it's more difficult to now seek SEC relief. So proponents are really less inclined to withdraw their proposals given the support that they've received, and companies conversely feel compelled to engage and to negotiate with proponents oftentimes in order to see if they can reach an agreement in light of these changing investor policies and the proxy advisory firm policies. But the issue guidance from the SEC last fall around the ordinary business exception and how it's been changed is definitely a key factor, as well as it is making no action relief a little more challenging to obtain this year. So essentially what you're seeing, and practically what you're seeing, is the SEC is allowing more proposals to go ahead under the Biden administration than what we had seen under the previous administration. And there's some data that supports this. Basically, as of March, there was about a 10% decline in the number of no action requests that were submitted. So these factors are all kind of coming together and creating a really interesting dynamic for this year's proxy season. And the last really interesting dynamic that I'll talk about on this slide is the increase in some new environmental and social shareholder proposal topics. So as environmental and social shareholder proposals are becoming more prominent and receiving more support, we're finding that there's new exploratory topics that are getting proposed, if you will. A lot of these topics deal with like worker rights and employee welfare. There's stuff around concealment clauses in employment agreements, and there were some specific proposals about COVID-19 vaccine distribution. Those are some of the interesting new proposal topics that we're seeing this year. And what I find kind of interesting about some of these proposals, the new proposals, is that some of them are really tied in close ways to the Great Resignation that we're seeing. And there's pressures on companies to attract and retain top talent, and there's competition in the market, as well as a push for increased worker rights. So it's interesting to see how what's happening in society at large is really impacting these shareholder proponents and the proposals that they're putting forth, and they can be pretty quick to put forward a new type of proposal that directly addresses a new concern in the country. So this slide here is a chart of what you can see are some of the most commonly filed shareholder proposal topics. It shows you both in 2020 as well as in 2021. So you can see kind of the shift, if you will, and an even greater emphasis, I would say, on the environmental and social proposals this year. So I think I have some time to go through a couple of these key topics, and I thought that might be useful for the audience to understand what some of the key points of emphasis are on some of these really prominent shareholder proposals. Let's talk with, let's actually go back to the previous slide, and I'll just run through some of the proposals. So I'll start with the racial and civil rights audits. So as I mentioned, 2020, this has exploded. There's an incredible increase in the number of proposals that are addressing this topic. And what are they looking to do, really? Well, proponents are asking companies to report on their plans to promote racial justice in the workplace as well as their operations at large. And the purpose is to try to assess the impacts that companies' policies and practices have on traditionally marginalized people or people who traditionally have been subject to discrimination. These audits, they're requesting input from a number of different people, a number of different stakeholders. They're looking at input from employees, customers, civil rights organizations. So it's really trying to get a broad base of view of how the company's policies are impacting society. And essentially what they're really trying to do, what they're really trying to get at is determining whether company practices have a discriminatory effect on people who have been historically subject to discrimination. These first started appearing last year, and they really started after the Black Lives Matter movement, as well as some of the racial justice protests that we saw after George Floyd's murder. So this has really increased in the past couple of years. It's a really new topic that's really increasing in frequency. Some of the companies that were initially targeted were companies that made public statements around discrimination. And now what you're seeing is there's some really prominent companies that are going ahead and voluntarily doing this. The advisors, the proxy advisors and investors have evolving views on this. As it's new, you're seeing some evolution. Last year in 2021, these proposals received support from on average, about like 33%. ISS and Vanguard frequently opposed them. Glass Lewis generally recommended 4%. But this year, we're seeing a potential turning of the tide, as there's already been 2 that have received majority support, one at Apple and one at Maximus, and none received majority support last year. ISS also updated its policy to really clarify that it's taking a case-by-case analysis of these policies this year. One of the other topics that I think is worthy delving into a little bit more deeply is the climate change proposals that we're seeing. So it's considered the largest and most prominent topic for the 2022 proxy season, where proponents are requesting targets, really ambitious targets, if you will, for the greenhouse gas GHG reductions targets in order to align with the Paris Agreement goal of achieving net zero emissions by 2050. And what investors are looking for is they're looking for companies to be specific in how they plan to reach these goals and what they're setting, the goals that they're setting. And some are asking for pretty detailed net zero transition plans. We're beyond the stage of just talking about what you're doing. Now it's really about measuring it and reporting back against those targets. So what we're seeing is some early support. Costco had a proposal on GHG emissions reductions targets that received nearly 70% support. Both ISS and Glass Lewis recommend in favor of it, and overwhelmingly the shareholders supported it. So you're seeing a real strong support potentially for this type of proposal going forward. There's also some assessments on the investors' expectations for directors around environmental issues, where this is becoming a potential voting item for directors, not just on shareholder proposals. You're seeing it with BlackRock. They voted against 255 directors last year due to climate-related disclosure issues and climate-related concerns. ISS has a new policy that is targeting a specific set of companies that are in the Climate Action 100 plus group. So there's an evolving view of the role of directors in overseeing climate risk management. So just the last slide that I have is the next one, and it talks about some of these proposals that received majority support. I've taken a good amount of time, so I want to give some time back to the rest of the panel, but a couple of trends I just want to highlight here. So all of these proposals that you're seeing here, ISS and Glass Lewis both recommended for, which is kind of that trend that I was saying. If that happens, you're looking at a proposal that's going to receive some really strong support. The other interesting thing is that the board opposed all of these proposals. So none of these proposals, not even the Jack in the Box one, where there's 95+% support, none of these proposals the board supported. So these are all situations where the board opposed it, ISS and Glass Lewis recommended for it, and then the majority of the shares cast voted in favor of the proposals. So it's some really interesting stuff. The other thing, if you dig into the proxy statements, you'll see that the companies are pretty clear in their desire to want to recognize the importance of these issues. And they're not dismissing these issues. And a lot of them have taken some significant strides to implementing policies that line up with what the shareholders are asking for. But ultimately, the proxy advisory firms and the institutional investors determined that they didn't think it was sufficient, or they thought that pushing them further would be a good thing overall for the company. So that is an interesting development that we're seeing this year. I think I've probably eaten up more than my time, so I will. I'll let you guys get back into it. I'm sure everybody is eager to start there. So
this is all super interesting, and we're seeing the same thing. On shareholders used to be institutional shareholders used to be looking for disclosure. Now there is a shift towards seeing confirmed impact, that the company is actually doing something to support those commitments, and that there is success of the ESG programs. And also, like you mentioned, Brian, I'm also seeing through the investor engagement that there are many more questions about what the boards are doing and what the companies are doing to govern climate change impacts and all other ESG related issues. So I will talk about climate change proposal, but very briefly, our firm did a survey of about 140 companies, both public and private, about 6 months ago. And at that time, the results were that 48% of the companies either already had ESG strategy in place or considered that strategy to be critical to them. Now, with the even continuing involvement of the investor demands and obviously the proposed SEC rulemaking, I think those numbers would be significantly higher. And if somebody doesn't have an ESG program in place yet, it is time to do that right now. So talking briefly about the SEC's rulemaking, this program would not be complete about discussing the climate disclosure proposal. I will not spend a ton of time on it. We have an alert which will be linked on one of the later slides, where it's described in excruciating detail, and anybody who's interested could go and read that. But sort of just a few takeaways. It's an incredibly broad, comprehensive, detailed proposal. It's 500 and plus pages. It's based on TCFD and the greenhouse gas protocol frameworks. It requires extensive narrative disclosures about climate risks over short, medium, and long term. Those are not defined, so there are challenges there too. Some of the rulemaking goes into talking about the risks of the value chain as well, which I think would be particularly difficult to comply with. There are quantitative disclosure requirements for the climate financial metrics, including the expenditures. That piece is very important because it goes into the notes to your financial statements. So it is subject to audit right away, which of course would be impacting timing. It's very difficult to get all of this information ready in 60 days that large accelerated filers have to file their annual reports. By comparison, ESG reports that are being currently produced, a lot of them are coming out in March or June or even later in the year. Of course, the biggest probably piece of the proposal that everyone is talking about is the requirement to measure and disclose greenhouse gas emissions. So scope 1 and scope 2 emissions, as well as scope 3 emissions for larger companies, if they are material to the company or if they are included in the company's emission reduction goals. So if we go to the next slide, just a quick demonstration of what those scopes mean. Scope 1 are the direct emissions for the company. Scope 2 are indirect emissions from purchased energy, steam, electricity, etc., that are consumed by the operations controlled by the company. And scope 3, this is where it gets to be really, really challenging, because that's the emissions from the company's value chain, including both upstream and the downstream. Basically, we're talking about the supplier activity as well as the customer activity. So moving further, a couple other items to highlight from the SEC's rulemaking proposal is for the companies that are setting targets and disclosing their net zero or any other targets, it might be time to sort of take another look at them. There will be a lot more information that will be required about those targets, and including about the company's progress towards them. From the financial statement piece, one other piece to mention is that it's an incredibly detailed rulemaking proposal. It's very burdensome. So if you look at the financial line item, if it's 1%, if the impact is over 1%, then desegregation is required. And then scope 3 is challenging because it's what some may not realize is that scope 3 constitutes the majority of the emissions for most of the companies. So for the SEC's release mentions 40% or something that could potentially be material. Now that's not a requirement or an endorsement, it's an example, but for a lot of companies, scope 3 is way above 40%. And finally, the governance piece, ESG governance piece is also very important. Now we have been seeing the investor interest and board organization and management organizations around ESG issues for quite a long time. So that it's not unusual to see those requirements. What this a little goes further is requiring disclosures about specific individual director qualifications and specific individual management qualifications around climate and climate risk management, which is also similar to the SEC's cyber risk management proposal that includes the same requirement. Again, this is disclosure, not a substantive requirement, but it would not be unusual to see it impacting the substantive company practices as well. So a few takeaways: impacts timing, impacts resources. There is XBRL tagging, there is a requirement for the independent third-party audit for the scope 1 and scope 2 for larger companies. A lot to do. Most of the time we wouldn't advise the companies to take action at the SEC's proposal stage. Here, even though the transition period seemed to be quite long, as shown on the next slide, it's actually not a lot of time to get done what needs to get done to put these policies and practices and controls in place. So why don't we move forward through a couple other slides. You'll see that the first compliance deadline would be for large accelerated filers, our biggest companies, for fiscal year 2023, in the annual reports that would be filed in 2024. And then the next slide shows the required third-party attestation report dates, where there a little bit longer than that, and we start with limited assurance and then move to reasonable assurance. So David, why don't you take it from here?
So now we've gotten all these new things that you have to undertake, and all the landmines that have been identified already, and you say, well, okay, well, what does this mean from an enforcement perspective? Well, the SEC has already been moving along on ESG issues. Probably most people know that they established this climate and ESG task force. And really, it was just looking at disclosure issues, as they always do. What are companies saying about what they're doing in the ESG space, and are those touts and those disclosures, are they actually accurate? When I think about this, sometimes I get a little philosophical about, what does this all mean? And I come down to this concept of materiality, whereas materiality always used to mean in the stuff that I do, what does it mean to the financial statements? But here it means that investors are valuing something other than just the financial performance of the company. And that's what they're looking at, because people want to buy green stuff. They want to use products and patronize companies that are, in their view, doing the right thing on these ESG issues. So it becomes incredibly broad. There are, right now, specifically on ESG issues, there haven't been actual SEC 10B cases filed on climate disclosures, but the Fiat Chrysler example is one where those kinds of disclosures of the accuracy of what you're saying about things like emissions can become a subject of SEC enforcement. A related SEC type of enforcement action, there was a disclosure by Activision Blizzard, for example, that they were investigating the company's disclosures on workplace harassment, gender pay, and other employment matters. It followed an EEOC investigation and an investigation by California. So these kinds of things have been going on for a while, but as the disclosure regime develops, you're going to see more and more of these kinds of investigations going on. Let's move to the next slide. From the standpoint of investors being interested in investing in companies that are ESG conscious, you see some enforcement going on. This Deutsche Bank disclosure that was done, that both the DOJ and the SEC have been investigating based on claims that were made by the former head of sustainability. I don't know about many of you, but I see advertisements about you want to get into a particular kind of fund or invest in a particular group of companies that are doing sustainable things. And what's at issue in the Deutsche Bank investigation is, are they actually investing in these kinds of companies? That's, again, a step removed from what are the companies themselves doing. But if you have your assets at Deutsche Bank, is Deutsche Bank actually investing your money in the companies that they say they're investing it in? The examinations for advisors are underway, and there was a bulletin that went out highlighting that recent exams have shown that not all the advisors are doing what they say they're doing when it comes to socially responsible investment. Let's move on to the FTC.
Yeah, so
for a long time.
On
Sorry, go ahead.
the front, just really quickly, I think it's not surprising based on what you just said that the SEC's latest enforcement priority agenda has greenwashing as #1, right?
Absolutely, absolutely. And the FTC, as it often does, also wants in on the action. There's the Green Guide's been out for a long time, and it's a document the FTC puts out that's sort of guidance on companies. What can you say about the environmental sustainability of your products or your practices? It's going to be updated in 2022, and it's probably going to be a doozy because there's a lot more interest in this. And even since we prepared these slides, the FTC brought actions against Walmart and against Kohl's, asking for penalties. In Walmart's case, $3 million relating to claims that they made about the environmental sustainability of some of their bamboo manufactured garments and fabrics. Same with coals, other bamboo-based products, and you know, it turns out they're actually made with rayon that it may have been derived from bamboo products, but the process of making rayon apparently involves some things that the FTC believes are not environmentally sustainable. So for anybody making green type claims, definitely check out the Green Guide. Let's move
It's
on.
very important when reviewing ESG reports too, because it's quite detailed. For example, very specific guidance, what you can or cannot say about carbon offsets. And David, like you mentioned, I expect that the 2022 guide will be substantially more detailed.
Right. And as you know, as often is the case, when you have increases in enforcement activity and regulatory activity lead to more litigation. More litigation sometimes spurs additional regulatory action. And these are some of the kinds of areas of litigation claims that have come up. In the corporate action inaction, it's been mentioned, the diversity issues, civil rights, employment type things, and then from a board standpoint, oversight of the company and its for directors, whether they are adequately overseeing the company's commitments in those areas. On emissions, it's actually broader than just emissions. It's sustainability claims. How green is your product, basically? There have been lawsuits, private lawsuits about that, and contract disputes relating to things like supply chain claims that can be made. Let's move to the next that goes into a little bit of the specifics. I bet you didn't think you'd see a banana on the slides, but that's reflects, this was actually, I think 10, 11 years ago, Chiquita Brands was sued by a nonprofit who claimed that its members were deceived into believing that if they bought Chiquita bananas, they were supporting a company that actually had environmentally sustainable agricultural practices, in part because it was certified by the Rainforest Alliance. That case was settled, and actually the nonprofit went on to sue the Rainforest Alliance for its certification practices. The water bottle represents the Fiji case, where Fiji originally claimed that its water was carbon negative, based on what it said was its ability to, if you parse through it down the road, they said that the investments that they were making in sustainability matters actually meant that they were offsetting more carbon than they were putting into the air. They were also, one other issue there was the labeling on its bottle that had a green spot, and the claim was that that suggested that there was some sort of a certification of environmental sustainability. Most of those claims were rejected. I think in 2019, Keurig, these coffee pods were claimed to be recyclable, and the claim was that in fact these, for most recycling systems, these pods are too small to actually be sorted out, and they claim they actually contain items that you can't separate one from another, so that they're not actually, as a practical matter, recyclable. So think about that the next time you pour a Keurig. Let's move on to the next slide. This is, you know, the broad scope of ESG litigation. Most people know that Commonwealth of Massachusetts has sued Exxon on its claims. The Dutch courts ordered Shell to cut global emissions of greenhouse gases by 45%. Shell had argued, well, geez, we've already said that by 2050 we're going to be carbon neutral, so this is ridiculous. But nonetheless, the court issued that order. Let's move on to the next. Board diversity. So far, those claims have largely been unsuccessful. These are some of the companies that have been sued on these. The cases have largely been dismissed. Let's move to the Goldman Sachs case. This is not an ESG case, but just for me, thinking about this question of materiality, it's very interesting. The case has been up and down to appeals courts and to the Supreme Court even, but this reflects the most recent decision, which was in December of last year. And the reason it's interesting from an ESG standpoint is the nature of the generic statements. In the case, the issue was whether class could be certified on the basis of Goldman's statements, generic statements about they had extensive policies on conflicts of interest and to identify and address conflicts of interest, and also that they put their clients first. And as most people who follow any of this stuff know, Goldman actually had some instances where one part of Goldman was promoting CDOs, collateralized debt obligations, and another part was betting against the success of those very same CDOs. So the question was, these kinds of generic statements, are they actually actionable? And the district court said, hey, people are making these kinds of generic statements, obviously because they think they mean something to investors. And therefore, we're going to say that, something, it can support a claim, and therefore a class can be certified. So I think it's instructive from the standpoint of thinking about the prospect of generic statements. And I think, you can get guidance from people like Gita about how to craft your statements so that you hope they don't become actionable.
Well, and I think the SEC's climate disclosure proposal was potentially such a fertile ground for litigation, right? Because on one, you have this massive amount of new information that will be required, and you have to look at how you say it, not to overstate where the company's at, to disclose the assumptions, to disclose the calculations. For example, what does net zero mean? There are so many definitions of net zero. What does being carbon neutral mean, right? And then in addition to that, David, you talked a little bit about the board sort of claims of oversight, so-called Caremark claims. So a piece of that is about protecting your board, because the board has fiduciary duties to implement oversight structures to address matters that are mission critical to the company, right? So when you're looking at the SEC proposal, again, we're not endorsing this, but it does lend some support to potential plaintiffs that perhaps climate change and managing and addressing those climate change risks is something that could be mission critical to all companies. So
what you find with plaintiffs' lawyers is that this will be fertile ground for them. And while they have tried and failed with many of the kinds of litigation that I've talked about so far, they are very resourceful and very creative, and you're going to find all kinds of new claims.
Sadly, right. So what to do next? I think most companies have already been wrestling with these issues. Many probably already have ESG programs. If you don't have one yet, do not wait for the SEC's rule to get finalized. There is a lot that needs to get done. It's going to take a very long time to build out those processes to make sure that the data is good enough to include it in the SEC reports. So if you don't have a program, start one. Make sure that it's something more than a check the box exercise. A good ESG program is the one that's really tied to the long-term shareholder value creation. And what I mean by that is that it's something that's taken seriously at the board level and that's integrated into both the company's enterprise risk management program, but also the company's strategic plan. So looking at the opportunity side of these things as well. ESG team has to be broad enough where enough departments are captured and enough business lines are captured that all the relevant data is being collected. If it doesn't include a finance function yet, it should be added because it's going to be getting into the notes to the financial statements. It's ESG program is not the same for every company. It's important for the company to conduct its own priority assessment of various ESG topics and determine what are the issues that are significant to your specific company. Again, now diversity and climate change are probably the two that every company will have, but that's not to say that these are the only two that the company should be focusing on. Measuring greenhouse gas emissions, that's the one that's given quite a bit of heartburn for some companies that haven't been doing that. You might find that you need to add additional internal resources or engage consultant help. It's important that that data is verified, that it runs through the company's controls and procedures. For the design of the controls, COSO has some suggested framework, but also looking at the company's existing financial controls as useful, being careful when setting greenhouse gas emission standards will be important as well. And then on the last slide, we have just a couple additional recommendations, so to speak. One is making sure that there is appropriate oversight at the board level that goes with appropriate qualifications and education. And then the last one, and that's the one that I will leave you with, is, so it's on one hand, we're designing ESG programs and we're making ESG disclosures. But then on the other hand, we also have to be careful about how all of these ESG commitments are interacting with other laws that are on the books. So for example, some states have laws that are designed to protect fossil fuel-based companies. If you're a financial institution, you might be concerned about consumer lending laws and whether your ESG practices are viewed as discriminatory. So it's a lot to look at, and it's important to build those ESG programs that are really adaptable and agile enough to encompass all of these new regulations and also new ESG issues that surface over from time to time, such as some M2 movement. We're seeing supply chain issues and a variety of other issues from Russia's invasion of Ukraine. So building systems that are not rigid, it's particularly important.
Can I chime in with some thoughts on these?
Of course, please do.
So one thing that I find when I'm talking to clients is, you've got a big cross spectrum of companies, right? There are companies who are pretty far and mature in their ESG journey, and there are companies that are much more new to the process. And I find that some of the companies that are pretty new to the process, really don't know where to begin. What is the first steps? And I think you identified a couple of the steps in here that are particularly, useful information for companies that are new to this or trying to understand how to initiate this process. I think doing that priority assessment, building out your team, and then doing that gap analysis, those are 3 steps where if you really haven't done much in this space, those are steps that I think are really a great place to start and give you a really solid foundation for building out a pretty robust ESG program as you mature further. That can be the basis by which you end up building out your disclosures and ultimately align them with some of the reporting frameworks that we're talking about. So I think those are some really great and valuable nuggets for people out there who aren't really sure necessarily where to take that first step, or how to, if they've taken some of the steps, how to take that next step.
And that's a great point. And if you just first starting out, there are different ways to do these things, and there are ways to scale them. So we hear a lot about priority assessment or materiality assessment, and we see these maps with engagement of various stakeholders, and sometimes it can be just overwhelming, especially for smaller companies. So it's just, again, there is no one size fits all. There are different ways to scale priority assessments too, for example.
And when you're doing that, and once you've kind of maybe taken that first step, and you've got a disclosure, or you've got maybe a tear sheet, socializing it with some of your stakeholders to get feedback and insights from what their perspectives are, that could be another useful component to that process.
Absolutely, before expending a lot of resources to sort of build out something that maybe it's not that important to your constituent base.
We do still have a little bit of time for questions, so if you have any questions for our panelists here, please type them into the Q&A. I guess I'll ask a few while we're waiting for people to send them in. Brian, you talk about environmental and sort of racial issues as being two major ones. There's one issue that sort of brings those two things together that we pay attention to, which is the environmental justice movement. Have you been seeing any shareholder proposals with that sort of in mind?
So that's really a very new initiative that really, I haven't seen it really bubble to the level of a ton of shareholder proposals on this topic, but I think this is the type of thing that you might see coming down the pipe, maybe next year or further down the line. I did another series of panels where we talked about each individual component in ESG, and on the E panel and the S panel, there was a lot of overlap on the environmental justice component. And with BlackRock being so interested in this, I definitely think this is the type of topic that is going to continue to gain more traction. But right now, I think it's still pretty new, and it hasn't necessarily risen to that level of support and really maybe even industry knowledge. I think that the just transition movement is really a pretty new idea that people are just starting to wrap their heads around, but we will probably see it increase in scope going forward.
So, Jurgita, how broad is the concept of Scope 3 data under the SEC proposal? For instance, would emissions from businesses that an insurance company insures be considered Scope 3 emissions under the proposal?
Well, you identify a very sore issue for many companies, I think, right? Because the framework is based, the proposed rulemaking is based on the TCFD and the Greenhouse Protocol, and the Scope 3 does include upstream and downstream emissions, and we are looking everything from the way suppliers make these products to the way that consumers use them. So for financial institutions, there aren't very many financial institutions or insurance companies right now that provide these things for obvious reasons, right? It's like it's immense undertaking, and it's not just the insurance companies; it's also banks and other financial institutions for lending and similar issues.
David, one of the focuses of some of the recyclable lawsuits that have been filed is that companies shouldn't say something is recyclable unless it's actually going to be recycled or likely to be recycled. That's not what the current green guides say. Do you see that there might be a chance that the green guides will go in that direction, that it'll be an even more stringent standard for companies to make the recyclable claim?
I do. I mean, I don't have a, pre-publication version of the Green Guide, but I would not be at all surprised, because I think the FTC views, whatever, I mean, they're just all over greenwashing, and they view any statement that is made as being something that has practical implications for the user of the product. So, I mean, I just know I was at a conference a couple of years ago, and somebody said, "Oh, I won't use those Keurig because they're not recyclable." And somebody else said, "Oh, no, they are recyclable. They claim they are recyclable." so there are people out there who actually care about this stuff, and I mean, I hate to sound like a broken record or a buffering website, but this concept of materiality just gets so much broader than it used to be, and I know that's an SEC concept and a securities law concept, but I think increasingly it's an FTC concept too. The more people care about a certain thing, whether it's legitimate or not, the FTC, the SEC, the CFTC, state regulators, they're going to be receptive to that.
So I guess the concern that we have as an institution is that if materiality equals stakeholder and shareholder interest, even however broad, however narrow it might be, that's what's material. Does that create, at least to you, a slippery slope here, where at some point nothing's material because everything is?
I think what you see with ESG is that the array of things that are material is just growing like topsy. And it's just, I don't know how companies can fully anticipate the breadth of that. And it creates minefields. We need some sort of certainty. We always say that, what businesses want, just tell us what the landscape is and we'll adapt to it. But here, as you say, it is a slippery slope, and what companies could disregard today, maybe tomorrow they can't.
One of the things that really sort of struck me in a recent Washington Post article was that Nestle's Kit Kat bars make a carbon reduction claim on the Kit Kat bar itself, but they don't. It's not the same as Nestle's overall claim for carbon reduction, and that strikes me as something that's just a lawsuit waiting to happen.
No doubt about it. It's you've got to watch so carefully what you say about your products, and I don't know if there's a lawsuit waiting to happen on Kit Kat right now, but presumably somebody's going to try to hold Nestle responsible, even though it's not the Nestle policy, it's the Kit Kat policy, and maybe it's the Kit Kat division within Nestle. And for some of these large companies, they're going to have to be aware of all of the divisions, representations, and how they're touting things in advertising.
It's just another example about how important it is to integrate these programs within the company. Another one would be some action that the state of Texas is taking against the financial institutions that were making sort of certifications to the state that they were not discriminating against the fossil fuel companies. And then on the other hand, there were the ESG reports and disclosures describing how those companies were on the path to reach net zero, right? So it's challenging, especially with these large global organizations, to sort of really bringing all the appropriate people at the table at the design and then the implementation stage, so that it's not being handled piece by piece and the left hand knows what the right hand is doing.
David, what can interested parties, stakeholders, regulated entities do to help educate the FTC as it goes forward with updating the green guides? Obviously, there probably will be a comment period, but what else? Is there anything else that they can do sort of in this phase where the consideration is going?
I think, there will be comments that will be submitted to the FTC. I think certainly if there are issues that companies or interest groups believe are contrary to existing law, or that existing law could be changed, lobby Congress. These agencies are supposedly, we could talk for a long time about the administrative state, right? These agencies are subject to the laws that Congress makes. And so if companies don't like what the agency is doing, go to Congress.
And the common proposal, just to sort of give an example on that, the SEC's climate disclosure proposal, we have what, 6,000 comments as of today? So it's
like another month to go.
Yep. Yeah. And potential extension of the comment period, right?
So would it be fair to say that you can add at least a year to the implementation of the SEC proposal, given that it's almost certainly going to be challenged legally?
I couldn't guarantee it, right? But it is the timeline, or maybe perhaps it's a guideline, but the current implementation timeline is aggressive.
It is aggressive, and I also, and as Glenn is saying, litigation's sure to follow. But even without those provisions going into effect, and even if, I mean, my guess is that some form of them will go into effect.
And substantial in a very burdensome way, whether
right.
whether it's today or tomorrow, right?
And what does that do to the sort of the overall environment of how people are thinking about ESG issues? And you know, it's sort of moving the debate even further in that direction. And until they go into effect, I think increasingly companies, as they try to do what Yogita is suggesting and build these programs and strengthen them, they're going to be making disclosures, and investors are going to continue to pay greater attention to them. So companies are going to have to address them, even if you don't actually have the final rules in effect.
Exactly.
Momentum was put in, I'm sorry.
No, go ahead, Brian, please.
The momentum was put in place a couple of years ago when institutional investors started mandating and requiring companies to make these type of disclosures, or there would be consequences from an investability as well as a proxy voting standpoint. So I think in the absence of SEC mandated disclosure, that would just continue. We saw it before. I think we'll continue to see it even grow in frequency. A lot of the proposal is built around the disclosure proposal is built around some of the TCFD requirements. So you already see these things. The wheels are in motion. This is happening. This is, I guess, what I'm trying to say.
Absolutely. That's exactly what I was going to say. You have the investors and you have the international community driving it as well. So the practicalities that I think we all know that the SEC's proposed rule will be challenged, but it gives me very little comfort from sort of practical standpoint as when we're talking with companies about building out these programs and disclosures.
So what Brian and Yogita had to say sort of brings us nice full circle back to what I'd said at the beginning, that all of these different moving parts when it comes to environmental, social, and governance are sort of all converging together and influencing each other and sort of churning things. So certainly, like Brian said, even if standards like the SEC's disclosure mandate don't become final anytime soon, you're still going to see companies moving in that direction, and disclosures beget mistakes, and those mistakes will be pounced on by trial lawyers and regulators, and it all sort of feeds back on itself. So one thing that's good for lawyers is that there'll be plenty of work going forward, which isn't great from our perspective, but it is good for you.
There is that.
So on that note, I wanted to thank everybody for joining us today. Brian, Yogita, David, really appreciate your participating in this. As I mentioned at the outset, this has been recorded, so it will be up on our website later this afternoon as an on-demand file. If you'd like to watch it again, send it to others that might be interested in watching it. And if you have any questions, don't hesitate to email me at glamy@wlf.org. Again, thank you for joining us.
Thanks for having us.